case you need even more.
Those are fine.
All right. Thank you very much. Judge Tatel, may I open court?
Yes, please.
Thank you, Judge Tatel. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-5106, Royce Corley, appellant, versus William Bellin Barr, Attorney General et al. Mr. Bouquet-Lindell, amicus curiae, Mr. Pfaffenroth for the appellees.
May I proceed, Your Honors?
Good morning. Yes.
Good morning, and may it please the court. Noah Bouquet-Lindell for the court-appointed amicus in support of Mr. Corley. Over 6 years ago, Mr. Corley submitted requests to 3 components of the Department of Justice under FOIA and the Privacy Act. Those statutes require agencies and courts to strike a balance between privacy interests and the fundamental need for disclosure, with FOIA placing an especially large thumb on the scale in favor of the latter. Yet throughout this case, the government has made a series of privacy-only arguments on every major issue. Those arguments conflict with FOIA's general philosophy of disclosure. In nevertheless granting summary judgment to the agencies in this case, the district court made 3 significant errors. First, the court allowed the FBI and the Executive Office for U.S. Attorneys to withhold documents under FOIA Exemption 3, even though the Child Victims and Witnesses' Rights Act is not a withholding statute and does not require withholding of the documents at issue here. Second, the court granted summary judgment to EOUSA when EOUSA failed to release any documents under the Privacy Act and never invoked any Privacy Act exemptions. And third, the court entered summary judgment without even recognizing that the Justice Management Division had failed to even conduct a search, though Mr. Corley had included a copy of his FOIA request with his appeal letter. For these reasons, we believe the judgment below should be vacated or reversed on these issues. Now, starting with the first issue, the Exemption 3 issue, in order to withhold documents under Exemption 3, an agency has to meet 2 steps of the standard. First, they have to show that the Child Victims Act is a withholding statute as a general matter. And second, even if it is, the agencies have to show that the documents that Mr. Corley is seeking fall within the statute's reach. If they fail to meet either of those 2 steps, then they are not able to withhold documents under Exemption 3. And here, the agencies would fail at both steps. At step 1, in terms of determining whether this is a withholding statute to begin with, Department of Justice versus Julian shows that this statute is not a withholding statute.
Well, Mr. Bouquet-Lindell, could you start with the language of the statute instead of the Supreme Court decision? It says, the statute says that all documents concerning a child shall be kept in a secure place to which no person who doesn't have the reason to know shall be able to see them. And then it has only one exception, right? It just says one exception. It says they can be disclosed only to persons who by their participation in the proceedings have reason to know. So why isn't this just, the standard is, the statute says that that a disclosure statute is one that, quote, requires that matters be withheld from the public in such a manner as to leave no discretion. And this doesn't seem to leave any discretion. It prohibits, it requires that they be kept secret, and it has one exception.
Right, and that again,
forget the Supreme Court in Lindell for a minute. Why isn't this statute just on its face an Exemption 3 disclosure statute?
well, because it does allow, it authorizes disclosure to certain people. And again, it's sort of hard to.
Yeah, but it's a limited disclosure to people in the context of a statute that requires that it all be kept, shall be kept in a secure place to which no person who does not have access has access. It's a blanket It's a prohibition on.
If I may follow up on Judge Tatel's point, isn't the key word only in 3509D1 II? Isn't that the key word only? You disclose only, meaning you don't disclose to anybody else?
Well, again, I think this is why I think it's a little hard to divorce this from the ruling in Julian, because the statutes at issue there were very similar. The only people who were allowed to have access to the pre-sentence reports in the laws at issue in Julian were the defendant and the defendant's counsel. And yet the Supreme Court said that because it allowed for that disclosure, it authorized that disclosure, it's not a withholding statute. And here, we don't have exactly the same level, of complete mandatory authorization, but we do have this situation where it clearly carves out people who are authorized to receive this. There's also subsection D4, which again reiterates that it does not prohibit disclosure to.
Okay, I don't mean to interrupt you, but before we leave the Supreme Court decision, it says, I'm looking at the language of the statute. It says that Rule 32 and the Parole Act didn't qualify because they were designed, quote, not to protect the reports from disclosure. Not to protect the reports from disclosure, whereas this statute does.
Well, again, though, in Julian, the statutes at issue there only allowed it to be disclosed to certain people. And so again, we have this situation where there's disclosure allowed to a certain small subset of people, but not necessarily to the public. And so they are pretty much on all fours. You have situations where both of them authorize disclosure to defendants and defendants' counsel. In neither case do you have an explicit time frame for that disclosure. And in both cases, with the Parole Act in Julian and here with the Child Victims Act, the people who receive the disclosure are allowed to hold on to it, even though they try to prevent further disclosure outward in both cases. Mm-hmm. And in Julian itself, it notes that there was a series of changes made to the statute in order to facilitate disclosure. And it says, for example, in 1966, they amended the rule to allow the courts to disclose this information to defendants. And then there were a series of further amendments that went even further after that. But the court was noting that this was a series of amendments, starting with the one that allowed courts to disclose this information to defendants, that showed that there was a desire to facilitate some disclosure. And the other thing to keep in mind here in terms of the text of the statute is that this statute was designed to balance the privacy interests at issue with the constitutional rights of defendants, as well as the rights of these other actors that the statute specifically created and allowed access to the proceedings, guardians ad litem, adult attendants, et cetera.
Mr. Boquet-Lindell, in the context of a FOIA search, Mr. Corley is not a criminal defendant.
Right, yes. And as far as his claim that he is able to directly receive this information under the statute, there is this question about whether he still qualifies as a defendant because he was the defendant in the proceedings at issue, but those proceedings have ended. I will note that when he requested these documents, he was seeking them in order to aid in his appeal. So while the trial proceedings were over, it was still part of his case. But regardless, the question for Exemption 3 is not whether under the statute himself he's a defendant, because even in Julian, the people there were no longer defendants, they were inmates, as the court said. They were not in the periods of time where the statute explicitly allowed for disclosure to them. They were just sitting in jail. They had already been sentenced.
What is your response to the government's distinction of Julian?
Based on the NRDC case, Your Honor?
The government argues that in Julian, the individual involved was a beneficiary of the disclosure, which is not true here.
Right, Your Honor. Well, first of all, he is in the sense that he is one of the people who was allowed to have this information under the statute, but more fundamentally, that argument doesn't deal with the Exemption 3 portion of the discussion in Julian. That deals with the Exemption 5 discussion in Julian. There were two exemptions at issue in Julian. And if you read through Julian, it does the entire Exemption 3 analysis without even talking about this question of a special access right. It's when it gets to Exemption 5 where they say normally we would not allow this information to be disclosed, but because this is the subject of the report themselves, they're the beneficiary of that privilege, that discovery privilege, that therefore we would allow this to be disclosed to this particular person. And if you look at Justice Scalia's dissent, that's where he joins issue with the majority, is this question of Exemption 5 and saying we are creating this special access right for one person. That's not part of the Exemption 3 discussion in Julian. And so I think that when we're talking about Exemption 3, that special access issue is not directly relevant. It's a question of whether the statute creates an authorization of disclosure to particular people. And one other thing I'd note about that on the text is if you look at subsection H of the statute, where it creates these guardians ad litem, it has subsection H2 of the statute, which specifically says the guardian ad litem may have access to all reports, evaluations, and records except attorney's work product necessary to effectively advocate for the child. So there we have yet another example. In addition to the privacy provisions themselves, including D4, we now have H2 in the statute where they're specifically creating this avenue for certain people to have access to this information.
Well, but the language of FOIA Exemption 3 itself that provides for statutory exemptions doesn't suggest that the statutory exemption has to be complete, right? I mean, the Exemption 3A Romanet 2 says, right, a statute establishes particular criteria for withholding or refers to particular types of matters to be withheld, right? It doesn't have to be everything is withheld or a categorical withholding of information.
Right, and again, the category that we're talking about in terms of what's even covered by the provision itself is this specific set of documents that refer to a child. But again, even within that, there's this question of, is it requiring withholding entirely? And again, that's where Julian comes into play here. Because even though, yes, it's referring to a specific set of documents, in Julian, it was referencing one particular document. It was referencing a pre-sentence report. So by the text of Exemption 3, it would seem to fall within Exemption 3. It's saying, here is this document that we are only allowing one person and their attorney to see. And there are certain types of information within that even that defendant can't see, and that information is withheld under Exemption 3. Mr.
Bocatlin, are you aware, excuse me, are you aware of our decision in a case called United States versus Bryce? Do you know about that case?
I don't think so, Your Honor.
I ask because I don't usually like to bring up cases that aren't mentioned in the brief. It's not mentioned in the government's brief, so maybe I'm missing something, and I'll ask them about it. But in Bryce, Bryce was a Section 3509 case, and we held specifically that the statute is, quote, not an affirmative disclosure statute, but rather forbids disclosure of sensitive information. That was a case where a criminal defendant was trying to get access to certain sealed witness materials. So, well, you're not aware of the case, right?
No, sorry. First of all, I noticed that I've gotten into my rebuttal time. Is it all right?
That's okay. You can keep going. I have a question about your argument about 18-year-old limits.
Yes.
So, under your theory, if there is a if there's a say a very graphic photograph of a 16-year-old, that document is not protected once that person becomes an adult. Is that right?
I think that it would be protected, but not under this particular statute.
But why would Congress have passed such a statute?
Because, Your Honor, I think, first of all, Congress was adding an additional layer of protection on top of all of the protections that already existed. Obviously, within the FOIA context alone, there are Exemption 6 and Exemption 7C.
But let's just stick with the statute for a minute.
Of course.
I take your argument about the definition of a child, but the Dictionary Act says you still have to look at context. So this statute refers to documents that, quote, concern a child. That's the language, right? quote,
Yes.
concern a child. So is a photograph, is a graphic photograph of a 17-year-old no longer a document concerning a child when that 17-year-old is 25?
I think it's
I mean, that
not, Your
can't.
Honor.
Go
I
ahead.
certainly think that's a plausible reading of the statute. I think that there are two problems with it, one textual and one in terms of consequences. In terms of the text, again, I think if we're talking colloquially in terms of saying what
I don't even
child
see
is,
why, excuse me, but I don't understand why a photograph of a 17-year-old when that person is 25 is not a photograph of a child.
I think, again, because there's a statutory definition as opposed to our normal way of thinking about what a child is, and the statutory definition refers to a person who is under the age of 18.
But the Dictionary Act makes it very clear that you look at the context and the purpose of the statute, and besides,
Yes, of course, Your Honor. And there again, I think a couple of things. One, the overall context of the statute and the purpose of the statute is meant to help people while they are children be able to tell their stories to law enforcement and to be able to testify at trial. And so again, the vast majority of the statute doesn't make any sense once someone turns 18. You know, appointing a guardian ad litem for someone once they're 18 doesn't make any sense. It has some legal problems with it. Same with having an adult attendant there and having the child be able to sit on their lap or hold their hand, which is something in the statute. But also,
Lindell, those provisions do not use the term concerning a child, right? So they all refer to a child. And so maybe that definition makes sense as someone under 18, you know, with respect to those provisions. But to Judge Tatel's point, I mean, why is a picture of a minor, you know, of a child, not always a document concerning a child? Because the document itself, the photo, or, you know, whatever material is in that document is always concerning a child, even if that person is now an adult.
Well, I think, again, this gets into problems of application as well. I think that it would have, you know, if we go beyond just thinking about a photograph, this would have some applications that seem very much at odds with the statute. So if you have someone who's 50 years old and for the first time comes out and says, when I was 10 years old, I was assaulted, and gives a statement to police, under this reading of concerning a child, that statement would have to be kept under lock and key forever, because the person it's describing events that happened when this person was 10 years old, but they're 50 years old now. That's when they made the statement. They're miles away from being a child.
They may still have a privacy interest in not having the public know, you know, some horrible acts that happened to them when they were a child. I'm not sure why that would change, whether the crime came out when someone was a minor or came out when someone was an adult. The privacy interest, I'm not sure why the privacy interest would be any different. And also that doesn't explain this, you know, concerning language, which seems to me, unless I'm missing something, only to be used with respect to the privacy protections, right? Suggesting that that is something different, right? You know, it's concerning a child. I think they use it, the statute uses that phrase multiple times in the context of the privacy protections, but not in the context of the other treatments of a child.
Right, Your Honor. Right. And I think that, again, this is a matter of not thinking about the word child colloquially and inserting the statutory definition of a child, and thinking about it, again, in context, as Judge Tatel pointed out, looking at what the statute is trying to do. Because, again, yes, they certainly have privacy interests if you're a 50-year-old and you're talking about something that happened when you were 10. But the question is, was this statute meant to deal with that privacy interest, or were previously existing doctrines, First Amendment balancing tests, for example, and in the FOIA context, exemptions 6 and 7C, were those already enough to handle that? And here, Congress was just trying to say, when we have a situation where we have children, a person who is under the age of 18, and they are in need of help in terms of telling their story to law enforcement and participating in the proceedings as they're occurring. And that's why it makes sense to think of this and to take the statutory definition seriously and to say it's referring to someone who is under the age of 18. Because
Counsel, let me forgive me for interrupting you a moment.
Of course.
But even without regard to the policy points that Judge Tatel raises, I read the statute the following way. I read the statute as 3509A defines who is the person we're talking about in the rest of the statute. And that's a person who is under the age of 18 when the crime takes place. Then you just take that person, the child, who you've defined in 3509A, and then you go to 3509D1, and it's the same child all throughout 3509D1, I, and double I. That's the way I read it, without even having the kids consider the policy questions.
Well, I think, Your Honor,
or the purpose.
Yeah, I think the problem there is that it adds words to the statutory definition. It adds
Why?
the words when the offense occurred, a person who is under 18 at the time the offense occurred. And we pointed to a number of statutes in our reply brief that actually do that. When Congress wants to set the reference point as the time at which the offense occurred, it says that. It either explicitly says under 18 when the offense occurred or something similar to that, or it says, you know, in the juvenile justice statute, it talks about a person who's under 18 when they committed the crime. And here it doesn't do that. And again, I point out that, you know, if we're looking beyond just the privacy provision, because the statutory definition applies across the entire statute, many provisions of this statute don't make very much sense if you're keying this to the time of the offense and someone could be far older than 18 at the time the trial is occurring, and you're talking about appointing a guardian ad litem, you're talking about an adult attendant, you're talking about having a competency hearing to determine whether they are able to testify. These are all provisions that are dealing with the situation that Congress had in mind, which is someone who is still a child in the midst of these proceedings and wanting to testify.
But that's
well, even under your argument, the best you would make is that it's ambiguous, right?
At the very least, I think it's ambiguous. And I think when you're dealing with this question of a withholding statute, I think that's something to pay attention to. I don't think, obviously, that means you need to have an unambiguous statute here, because we're just dealing with FOIA as opposed to the entire interpretation of the statute. But I think it's something to keep in mind. I would also point out that you only get this far if you first get past the question of whether this is a withholding statute to begin with.
Right.
And for the reasons we stated, we don't think it is to begin with.
Okay.
Well, I find your argument on that point rather weak because of the word only. I'm sorry.
That's all right. Unless my colleagues have any other questions, are you okay, Judge? Okay.
Yes, that's okay.
Let's hear from the government, and we'll give you a little time on rebuttal. Okay?
Thank you.
Good morning, Your Honors. Peter Pfaffenroth for the government. The privacy question, this entire provision that we've been discussing is about privacy protection and quote unquote confidentiality of information. And it's about protecting children. That's what Congress was doing by enacting this statute. The notion that the statutory language defining child somehow evaporates when someone becomes 18 because that happens to be the moment when they testify, or that happens to be the moment when the victim finally takes the stand, or a witness finally takes a stand, just doesn't make sense in either logically or in terms of the statutory language itself. You are a victim the moment that Mr. Corley sexually traffics you. And in this case, the jury found that each of the girls was underage at the time, and that issue is simply, settled law. The Second Circuit has affirmed it, and it's a done
counsel.
issue. Yes.
Excuse me, counsel. Would you agree with your opponent that the statute is ambiguous?
I don't think it is.
What about you're reading it as child is defined as a person who is or was under the age of 18. Isn't that correct? That's the way you're reading it.
I don't think that's actually a necessary way to read it.
No, that's the way you're reading it. Isn't that the way you're reading it?
I'm reading it that, Judge Silberman, I don't mean to fight you on this, but the person is a
Go right
victim
ahead.
at the moment that they are sexually
Go ahead.
trafficked, and that status never ends.
Excuse me, counsel. Go right ahead
Sorry.
and fight. It's your job.
Thank you, Judge. I don't see it as being ambiguous, Your Honor. The person is a victim, and that person will remain a victim for all time because she was sexually trafficked by Mr. Corley when she was 16 years old. She is a victim forever. Yes, hopefully she'll live to a ripe old age, but she'll still be a victim of sexual trafficking of a minor.
I think I understand your point. Let's assume, however, arguendo, that it's ambiguous. Then what?
Then Congress did the balancing, and the reality is that the notion that FOIA is a disclosure statute and therefore we have to err in favor of disclosure, that notion really doesn't have much force in the Exemption 3 context where Congress has already done the balancing, right? If we were talking about some of the national security statutes that, are well established as Exemption 3 withholding statutes, even if there was a little bit of ambiguity there, the fact is Congress determined that national security secrets need to be kept secret, and we're not going to interpret that ambiguity in favor of a requester because Congress already did that balancing.
But you didn't quite answer so what is the doctrinal basis on which we would decide in your favor if we concluded Section 3509A was ambiguous? We can't give deference to the agency under FOIA or the Privacy Act, can we?
No, there's not a single, the Department of Justice as the agency that is applying all of these criminal statutes and is the agency that is clearly charged under the statute with, prosecuting the individual. I mean, the Department of Justice is actually referenced in Section D1B.
Wait,
Nonetheless,
are you suggesting we owe deference to justices?
I'm not suggesting that. I don't think that this is a. Nonetheless, I mean the fact is, if there were any such agency, it would be DOJ.
The fact is, we don't. Correct?
You don't. No, that's true.
Okay. So why don't you just set that aside? Isn't the answer to Judge Silberman's question? Well, you then look at the policy underlying the statute. Doesn't that help us?
Certainly.
Or doesn't that help you?
Absolutely.
He would say, if I may rephrase, Judge Tatel, is this a legitimate place to look at the purpose of the statute? And his hypotheticals, if you think about them, are a reduction to absurdity. His hypothetical of the picture being distributed on the internet 20 years later is so horrifying, Congress could not possibly have meant that. Isn't it?
Right.
That's right, Judge Silberman. The purpose of the statute clearly is to both protect the privacy of the individual who was victimized as a minor and to keep protecting that person, right? The statute talks about keeping the material under seal, and there's no time when that sealing expires in the statute. And Congress also, I think it is reasonable to infer, given the overall provisions of Section 3509 in terms of facilitating potentially very nervous children to participate fully and meaningfully in criminal prosecutions of their assailants, would want to provide a variety of ways of making those children comfortable. And other provisions talked about, having a guardian ad litem or somebody that they could sit on the lap of or what have you. But this provision was all about the privacy, and many children would reasonably, and their parents who are advising them and things like that, would reasonably be very concerned about the long-term implications of the facts underlying this prosecution coming out later and causing re-victimization to the children.
I don't care for normally referring to the purpose of the statute as opposed to the text. But if there ever was example where it might be legitimate. It might be in this case. If we were to decide on this issue against you, the Supreme Court would reverse 9-0 because they don't care about text as much as purpose.
Your Honor, I think the Supreme Court has already hinted, or well, not even just hinted, it's said how it feels about this issue generally before Section 3509, what became law in Globe newspaper, where it talks about the critical importance of protecting against psychological and other harm to child victims of sexual abuse.
Yep.
I asked Mr. Bocat-Lindell about U.S. versus Bryce. Do you know about that case?
Your Honor, I confess that in my research I clearly missed it, and I apologize.
Judge
Do you know the
Tatel, is
case?
that your, is that your
I don't know the case.
Okay. All right.
I'd
Well, that's
be
all
happy
right.
to
That's all right.
research it.
Maybe I just missed something. That's all right.
Judge Tatel, is that your
Just
opinion?
curious about why no one cited.
I'm sorry, I
No.
didn't,
Not me.
it's not your opinion.
No.
If it would be helpful to the court, I'd be happy to research it and submit a letter or whatever you'd
No,
like.
that's okay. No need to. No.
The
no need
last
to.
thing we need in this case is longer briefs.
I hear you, Your Honor. It is a little bit of a challenge when I had a lot of briefs, including from the pro se appellant, that I had to respond to.
Right.
Any other questions? Do you have anything else you want to add? What about anything you want to say about the other issues?
I would like to rest on our briefs, Your Honors, and if I would simply ask that the decision be affirmed.
Okay. Thank you. Mr. Bocat-Lindell, you can take 2 minutes.
Thank you. First, just a couple of points on that, and then a couple of points on the issues that hadn't been discussed. First, as the textual point that Mr. Pfaffenroth was making about a victim or witness being a forever status, that's very much true. And so grammatically, you say someone is a victim or witness forever. That's not the same when you're saying someone is under the age of 18. Once you turn 18, to say that this person is under the age of 18 no longer makes any grammatical sense. So I think that those two things, even though you use is for both, grammar clearly creates a difference there. I also think that, again, you're having to balance constitutional rights here. And the Globe newspaper decision shows that there are other ways to balance these rights aside from just this statute. So we don't necessarily have to read the policy of the statute to the ends of the earth in order to...
What are the constitutional rights at issue in a FOIA request?
Well, it's not about the FOIA request, Your Honor. It's about the statute itself. And in the statute itself, Congress was balancing privacy rights against the constitutional rights of the defendant. If the defendant and the defendant's counsel were not allowed to receive a lot of these documents, you could have Brady problems. You could have
but that balancing you acknowledge is not at issue here.
It is, in the sense that Exemption 3 is about the underlying statute. It's not so much about FOIA's interests. It's about what does the statute itself say and what is the statute itself doing. And when you're just doing a statutory interpretation of the Child Victims Act, I think you do have to consider the fact that there was this balancing going on in the creation of the statute itself. On the other issues, I want to point out that on the EO-USA Privacy Act issue, the only arguments the government has were that these are not agencies, even though clearly the statutory definition of agencies includes these subcomponents. And this court has gotten very close to the line of already saying that these are separate agencies. And as we point out in the reply brief, none of the documents that they point to actually shows that EO-USA made Privacy Act exemption arguments, and likewise didn't show that the Justice Management Division had not received the appeal letter from Mr. Corley on that issue. I see I've gotten over my time.
Yeah. Okay, thank you. Mr. Bocat-Lindell, you were appointed by the court to serve as amicus, and we're grateful to you for your assistance. Thank you.
May I add to that,
Yes.
Judge Tatel?
Please.
I think it was a superb brief.
Yes.
And an excellent argument.
Well, thank you very much, Judge Silberman. I appreciate that.
Can anybody tell me what's happened?
We're just waiting for her to open the next case. I think it takes a minute, Larry.
Got
It
it.
takes a while for me to send a request to the attorneys to turn their video on, but everybody is ready now. Case number 20-1152 et al. National Hot Rod Association petitioner versus National Labor Relations Board. Mr. Roberts for the petitioner, Mr. Francisco Fitzmaurice for the respondent.
Good morning, Your Honors. This is Charles
Good
Roberts.
morning. Good morning.
May it please the court. I'm here on behalf of the National Hot Rod Association. Let me start by saying that the National Labor Relations Board conducts hundreds and hundreds of representation elections each and every year. And having appeared before the board for more than 40 years, I can say they generally do a bang-up job, a Class A job. Unfortunately, in this case, this is one of those rare cases where, in all candor, the regional office in Newark just simply dropped the ball in its supervision of this national mail ballot election. Specifically, it sat on requests from 2 employees for duplicate ballots for 4 and 5 days, thereby ensuring that they could not cast a ballot in a timely fashion. Now, this was an election that was decided by a single vote. So if either one of those 2 employees was disenfranchised under the board's precedents, then that would be a basis for denying enforcement to the board's order. Now, when we first presented this case, it was our initial belief that this was negligence on the part of the board or the regional office, that they had simply provided an incorrect phone number or one that was not regularly monitored. That was based on the testimony of one of the employees as to what he was told by one of the supervising board agents. But now in this court, and this is the first time the boards had to take an official position on it because they weren't really a party down below. So they've taken the position that they did, in fact, monitor this phone number, which in our view makes it their failure even more egregious in the sense that it was a conscious decision, apparently, not to respond to these requests. Now, let me kind of frame the legal issues. I mean, there's no question based on the board's precedents and this court's decisions in Antelope Valley that in a disenfranchisement case, the employer or the party that's objecting has to show 2 things. One, it has to show that there was some election irregularity that is attributable to either the board or a party. And 2, it has to show that a determinative number of voters were possibly disenfranchised. It's not certainty of disenfranchisement, it's the possibility of disenfranchisement. And it's an objective test. Now, the board's position in this case appears to be that there was no election irregularity at all. And we find that position to simply be untenable. We start with the fact that there was basically a 17-day window period. The ballots were mailed out on November the 15th. They were to be counted on December the 2nd. So you had a 17-day window period. And the notice of election told employees that if they had not received a ballot by November 22nd, to contact the board immediately. The record reflects that on the following morning, November 23rd, which was the day before Thanksgiving, at 11:56 a.m., employee Robert Logan left a voicemail on this particular number that had been provided requesting a duplicate ballot. Based on the board's representation that it monitored the phone number, it apparently consciously refused or declined to send a ballot out that same day, even though it sent out 3 duplicate ballots to other employees the very same day, 2 of whom were able to return timely ballots. Now, the following day was Thanksgiving, and then on Friday, December the 25th, another employee, Paul Kent, left a voicemail at 11:32 a.m. requesting a duplicate ballot. And employee Logan, not having heard anything back at 3:21 p.m., made a second request for a duplicate ballot. Again, no action was taken on these on Friday, November the 25th. Over the weekend, Logan attempts to find out phone numbers and emails and eventually obtains a phone number, which he contacts apparently on Monday, and is able to reach the board agent. At that day, they send out a ballot to him, but by now we're November the 28th. He's in Michigan, the regional office is in Newark, and the chances of him receiving a ballot in a timely fashion have been severely diminished. And in fact, he does not receive it in a timely fashion. Strangely, even though they sent him a ballot that day, they waited till the next day, Tuesday the 29th, to send Kent a ballot. So here we have, it's hard, there's just no way you can say this is not an election irregularity attributable to the board. And what's frustrating is it's wholly unexplained. There's never been any explanation. If there were some justification, we should have heard it by now. But basically, so what you have is they sat on these requests for 4 and 5 days, thereby preventing a reasonable opportunity for these two employees to cast ballots. And then we get to the second stage of it, which is, were they possibly disenfranchised? As I said earlier, we know that Logan, if they had sent him a ballot on the 23rd, 2 of the 3 employees who got ballots that day or were sent ballots that day, one in Missouri, one in Nevada, were able to return ballots in a timely fashion. So we know that Logan could have voted, or highly likely that he could have cast a timely ballot if he'd been mailed one that day. Even on the 25th, the day before the weekend after Thanksgiving, you're still 7 days from the election. It's certainly reasonably possible that Kent could have received his ballot in a timely fashion. So what we have here is basically an unexplained failure on the part of the board. As I say, it's the exception, it's not the rule in these board cases.
Mr. Roberts, could I ask you just
As far as you're concerned, can this case be decided on the basis of...
Judge Tatel, excuse me. My
Sorry.
My
Yeah, go ahead.
iPad only shows one person at a time. What happened? Is a courtroom deputy able to help me here?
I'm sorry, what's the matter, Larry? Larry, what's the matter?
See, I don't see everybody before me. I see you and a little picture of me, but I don't see anybody else.
Maybe go to grid view up in the top right corner. There should be of your Zoom screen. It might say speaker view or grid view.
I don't see that.
View with
right
3 little.
It just says REC.
REC.
Well, Larry,
Right.
can you hear? Can you
Yes,
hear?
I can hear. I can hear,
Okay.
but I can't. If I'm looking at you, David, I can't see counsel and I can't see Naomi. Now I know you're impressive, David, but I would like to see somebody else.
I was about to say, why isn't that enough? But
I knew where you were going.
well,
Do you see anyone? I'm
do
sorry.
you want to? Ann, are you there?
I am here, Judge.
Can you see what the problem is with Judge Silberman's computer?
Right. Judge Silberman, in the top right-hand corner, do you see 3 little dots?
In the top right-hand corner, I only see a little red REC and a green dot above it.
Do you see anywhere at the top of your computer or of your iPad 3 little dots?
No. And this was
All right.
perfect in the last argument. As soon as we went to this argument, everything got screwed up.
I believe something may have happened with your device. We would need to get into your settings. The way to access your settings is to find those 3 little dots. You may have a new version of Zoom update for iPads.
I found the 3 little dots.
All right. Please click on these 3 little dots and you will
I
see a
did.
drop-down menu.
Yes, I see it.
The first option should be meeting settings. Please click on meeting settings,
Press that, huh?
right?
Or
You
on
should
the
then
left.
see a new, you
Then
should
I
then
see
see
a
a new
whole-
window.
Yes, with all kinds of options.
All right. The third option from the bottom should be show non-video participants. And
Yep.
that
Okay.
option should be off.
Oh, it
You
is,
should also,
it
all
is
right,
off.
you should also, okay. Do you also have an option about gallery or speaker?
Says show
Judge?
self view.
You do not need to do this, Judge. Hmm.
What do I press? Meeting topic, always show meeting controls, touch up my appearance, closed captioning. I didn't touch anything when we switched to the second case. It's just all of a sudden.
I understand. I believe your device, something happened to your device because you should be getting the option of switching to gallery view. And I am not sure why your device is not showing it. It should be in your settings along with everything else. I don't know if you would like us to look at your device after the arguments.
Okay,
The option should be right there.
I'll go back to where we are then. Now I only see you and a little picture of me and nothing else.
Okay, now I'm speaking. Can you see me now? Now that I'm speaking?
I can see you dramatically. You occupy my whole screen except a little bit of me. But I guess
Okay, so Larry, are you okay? Are you okay just listening to the rest of it then? Can we go ahead?
Yes, I think we can. But I
Okay.
hate
Mr. Roberts. Yeah.
Yes, you're
Mr.
right.
Roberts, am I oversimplifying your case by simply saying that the case, as far as you're concerned, the case can turn just on Logan, correct? Alone.
That is correct.
Because Logan, let's see, the notice from the regional office said that employees who don't receive a ballot by a certain date must communicate immediately. He did that twice to the designated phone number.
Yes.
So in your view, that resolves the case?
Yes, I do. If you agree with me on Logan, there is no need to address the other. I mean, a single vote.
Nor is there any need, in your view, to go beyond the fact that the board gave him two numbers. He called one of them twice, got no response. End of the matter as far as you're concerned?
Yes, I would just say quickly that to the extent that the judge found he should have called the other number, there was no need to. And the board's position is they knew they had already received his voicemail. Leaving another voicemail would have been pointless. So we think he complied with what was. Well,
the agreement, the notice didn't say he had to call them both, right?
No, it said either or, but the judge said he should have done more. And we dispute that position. But yes, Logan is the most clear cut of the ones, and I think he's determinative in and of himself. I just
Mr. Roberts?
Yes.
If we find for you on the voter disenfranchisement issue, do we need to reach the second issue about whether the board abused its discretion in not opening the ballots?
Well, the only difference would be in remedy, Your Honor, because on the first issue, the remedy, as I see it, is deny enforcement. The board then has to revoke the certification and hold a rerun election. On the second issue, in theory.
Wait, counsel. I think Judge Rao asked you whether you need to even discuss the second issue if we decide in favor of you on the first issue.
Well, my only point is that on the remedy on the second issue could be if the court ordered order the board to open those three ballots, which could, in theory, shift the vote to where it's no longer determinative. In which case,
but counsel, isn't your correct answer that if we decide, as Judge Tatel pointed out, if we decide in favor of you with respect to Logan, isn't that the end of the case?
I'm happy with that result. I will stand on that, Your Honor.
Happy? That's your win, isn't it?
It is, Your Honor.
Because Mr. Roberts, I think that there may be some difficult exhaustion questions with respect to the second issue, which is one of the reasons I asked whether we need to even reach the second issue.
I will gladly, I hate to say waive the second issue, but certainly stand on the first issue and take the position that if the court were to rule in our favor, we certainly have no request that you visit the second issue. Only if you obviously.
Can I just understand? I just want to understand your point about that, and I don't want to push this any further than we need to. But I understood your argument on that being that if they open those, you might win the election, right?
That is the point, Your Honor. But again,
but then let me follow up on what Judge Rao said. She mentioned exhaustion. Did you raise this issue with the board?
It's in
opening the ballots.
It's raised.
Where did you raise that?
It's raised in the objections.
You raised.
It's in the objections that were filed. The objections pointed out that there were still 17 challenged ballots that had yet to be opened, and that these ballots, that there were, in essence, there was no final tally of ballots on December the 2nd. There were 17 challenged ballots that were 15 of which were opened 8 months later. In our objections, we asserted that was on the ground that they could be opened along with those ballots. We did not, in all candor, we did not subsequently, after the objections, go back to the region and say, hey, you need to reopen these at the same time. So we did not reiterate the request, but the request was made in the objections, which are in the record. I don't have the page numbers before me, but they are in the joint appendix.
All right. Well, thank you. Any other questions, Judge Rao, Judge Silberman?
No question.
Okay, we'll hear from the board then.
May it please the court. My name is Brady Francisco Fitzmaurice. I represent the National Labor Relations Board, which is here seeking enforcement of its order finding that the company violated Section 885 and 1 of the Act when it refused to recognize and bargain with the union after the majority of its television production employees voted in support of the union in a mail ballot election. I'd like to start out. There are just a few points I'd like to clean up based on Mr. Roberts' argument that I think could bear correcting. A point was raised that the board admitted in briefing that it monitored the phone line and intentionally sat on.
But could you just go back to the beginning? Could you just, instead of cleaning up these spots, could you just respond to his final point that, look, this case turns on Logan himself. Logan, quote, Logan did exactly what the notice said. He, quote, communicated immediately, very next day. He called one of the two numbers. There was no response. Mr. Roberts says that's it, ends the case.
Sure, I'm happy to do that. So
Let's
as
just
to
start
Logan
there.
and all the employees, the issue here is whether
just Logan. Stick with the facts of Logan.
Focusing on Logan.
He called the board's designated number twice, got no response.
He did. On November 23rd, Wednesday, the day before Thanksgiving, he left a voicemail requesting a duplicate ballot be sent to him. He did so again on Friday, the 25th. That's correct. Now, what the board found was that under the circumstances that Mr. Logan was aware of, the urgency of the election and the count being scheduled to take place the following week, he didn't do everything he could have. He didn't follow every avenue available to him to request a duplicate ballot. The second phone line was available to him, and he did not call that.
But the notice did not say he had to call both of them.
That's correct. The notice used the word "or," giving the local phone line as well as the national phone line. However, in the stipulated election agreement that the parties voluntarily agreed to, the parties agreed that these requests should be in by 5 o'clock on Tuesday, November 22nd.
Wait a minute, counsel. Wait a minute. Wait just a second. Look, you suggest that he should have done the extraordinary thing of calling the second number. But why would that have been any good when you've admitted in your brief that you monitored the first number?
So as to the first number, the board's position is that it was the company's burden to prove that line was not monitored, and the company didn't. Wait.
You admitted you monitored.
Well, what we wrote in our brief was that the evidence did not prove that line was unmonitored, and that there's evidence suggesting that the line was in fact monitored. Another employee.
Oh, that's enough. I read your brief as stating that it was monitored. So why in God's name can you take the position that he should have called another number? You already received his request.
Of course, the board did receive his request and responded to it on Monday, November 28th.
5 days later.
Yes, that's correct. Which is, given the weekend and the holidays, 2 business days.
The only point I'm making is the second number argument that you're making doesn't make any sense when you admit you received his request at the first number.
Well, with respect,
Judge,
Judge,
when you did that, counsel leaped on it because you were hoist on your own petard.
Your Honor, notwithstanding that quip, I have to respectfully disagree that it wouldn't matter. Mr. Logan was under the circumstance where he knew that he had waited until, the absolute last day he could expect to receive the ballot, and then the following day made a request. He didn't talk to anyone. He was not aware, at that time that the request would be received or processed, and rather than call the other number available to him, decided to wait and then call the same number again the following business day on Friday. So I don't think it's an extraordinary request or burden to ask someone to call a second phone number. And the board found that.
Why? What good would that do when you monitored? You received his first number. I don't see your position. He could have got the chairman of the National Labor Relations Board's phone number in Washington and called that too.
I think my point is that, a second phone number would have gone to a different person who may have answered the phone, and he may have had a conversation.
So in other words, you're basically admitting the first person he talked to was incompetent.
No, I'm not, Your Honor. He didn't speak to anyone on the 23rd
Well,
or the 25th.
he left a voicemail. Somebody read it, and somebody did nothing.
No, that's not right, Your Honor. What the board did was, after receiving that voicemail on Monday the 28th, sent out the duplicate ballot to Mr. Logan. The counsel for the company stated that on the 23rd, the region sent out 3 duplicate ballots, but for some reason didn't send out Mr. Logan's. It is true that the region sent out 3 duplicate ballots on the 23rd, but the record does not disclose when those duplicate ballots were requested. So it's not the fact, the record does not show that, on the 23rd, the board received 3 requests and Logan's and decided only to respond to those 3 and not Logan's. It may have been the fact that those 3 requests were made previously, and there may have been a lag of 1 or 2 business days. I don't know. That's not shown in the record. But the broader point is that no matter
a few minutes ago you said that you thought it was relevant that Logan waited till the last minute. But right, that's what you said. But
Yeah,
the
that's
notice
right,
says, but the notice says employees who did not receive a ballot by November 22 should communicate immediately. That's what he did. There's nothing that suggests he needed to act, that it was irresponsible for him not to try to get a ballot on November 19th and November 20th, is there?
You're absolutely right, Your Honor. I don't mean to suggest that.
So then that's not relevant, right?
Well, no, it is relevant.
Why?
What I'm saying is 2 things. One, the board made clear that it was not going out of its way to fault Mr. Logan in the pejorative sense, and that's language from a board case for sale. But at the same time, the board recognized that, as you get closer and closer to the election, it becomes more and more urgent. And, it makes sense, it only makes sense to do everything you can to request the duplicate ballot. Here,
but look, you mentioned the agreement also. Now, the agreement and the notice are different. I can see your point if we were arguing the agreement, because that says that employees who didn't get a ballot should contact the region's office by no later than November 20th. You might have had a point then, but the notice doesn't. The notice says if you don't get it by November 22, contact us immediately. I just don't see how it's at all relevant that he waited until that date.
Yeah, you're absolutely right, Your Honor, that
okay.
The notice doesn't have that exact time, but it wouldn't have made a difference.
So then what's left of the board's argument here? He called the number twice. It's either that he should have called the other number, but as Judge Silberman points out, the board has conceded that it wasn't monitored. So what's left?
No, Your Honor, the board has not conceded that either phone line was not monitored. I have to make that correct.
No. It's worse. You conceded it was monitored. So in other words, you received.
That's what I meant. I misspoke. Sorry, I misspoke. Right.
So what happened here was Mr. Logan on the 23rd called the phone number at the region to request a duplicate ballot. Even if the board had received that voicemail and the very instant sent out a duplicate ballot, it would not have made a difference. Mr. Logan's original ballot was sent out on November 15th, the same day that the original ballots went out to each and every employee. He didn't even receive his original ballot or the duplicate ballot until after December 2nd, the day of the official ballot count. So his situation can be chalked up solely to the vagaries of mail delivery. And the courts have held uniformly that the vagaries of mail delivery are not a reason to overturn an election. I would also point to the Third and Second Circuit cases, noting that perfection is not what's required in an election. If that were the case, employees might never achieve their choice of representative. There are always going to be, certain things that pop up here and there. It's very unfortunate that Mr. Logan didn't receive either of his ballots in time to vote. And that the board noted that that's regrettable, of course. However, it's not a basis for overturning the results of this election, where 73% of the employees in the unit did cast timely ballots. The board successfully processed 21 requests for duplicate ballots, and many of those employees cast timely ballots. To overturn the results of the election would be to take away all of those employees' choice of representative. I see that I've gone over time here. Unless there
anything else, Judge Rao, just anything else?
No.
Okay.
No.
The board thanks the court for its time, and we ask that it enter judgment in full.
Thank you. Mr. Roberts, you can take a minute if you would like it.
Yes,
Do you want to say something? I won't count this against you. What about this argument about the vagaries of mail delivery?
that was what I was going to respond to.
Oh, good. Okay.
It's the possibility. It's not the certainty. And the fact that the original ballot wasn't received till after the deadline says nothing about whether the second ballot would have been delivered on time. As I say, 2 of the 3 people who were mailed ballots on the 23rd returned them, one from Missouri, one from Nevada. We cannot say that that delivery to Michigan would not have been made in a timely fashion. Logan was obviously interested. He was clearly making the effort. And basically all we have to show is that there was a reasonable possibility that he could have voted, and that's the vagaries don't come into it. We would ask that the board's order be denied enforcement. Thank you.
Okay. Thank you very much. The case is submitted.
This honorable court is now adjourned until Thursday, February 4th at 9:30 a.m.
Tricia?